Good afternoon. This is Sean Golding with Golding & Golding, here to discuss a common issue question that we see often. It will not be a long presentation, so you just need a few minutes. And the question is whether the first time abatement applies to reduce or eliminate international penalties. The answer is no, but let's kind of walk through it. So the first time abatement is for taxpayers who may have received a penalty for failing to do certain things they are required to do by the IRS. Typically, it applies to items such as failure to file and failure to pay. You get certain penalties for failing to file, for failing to pay. It's based on a monthly amount, reaches a certain cap, and then interest accrues and yada yada. So the question then becomes, what other types of penalties are abated using the first time abatement? Unfortunately, there really aren't any other ones other than certain people who have to put deposits down with the IRS. If you want to take a look through and see something called the Internal Revenue Manual, which is a great resource. It's designed to assist IRS professionals who work there on how to handle certain aspects of day-to-day life as being an IRS person. Chapter 20 refers to various penalties and first-time abatement, and in fact, it's like 20.1 point, I think 1.8, etc., etc. But it gives examples of specifically when the first time abatement does not apply, and some of the forms that they include is the 8300 for certain businesses, 3520 gifts, 5471 foreign entities. One thing to consider, even though having to file the first time does not qualify for the first time abatement, it is a factor in determining whether your penalty could be reduced, waived, or eliminated. In other words, when you have a foreign penalty, let's say you receive a CP15 notice for failing to report a foreign gift, or FATCA 5471, even though there's a current case that would prevent the IRS from doing that, at the end of the day, if you are trying to waive a penalty or avoid a penalty, you want to try to show reasonable cause based on the totality of the circumstance. Part of determining the totality of the circumstance is to determine whether or not you've been having to file the same form in multiple years, or if it was the first time you had to file the form. Maybe you received a one-time large gift from a family member. You may not have had any requirement to file Form 3520 in prior years until the year that you missed it. That was the first time you were required to file, and that could be a factor in trying to get the penalty eliminated or reduced or waived or abated or whatever term you want to use. So in other words, international penalties do not qualify for the first time abatement, but it being the first time you have to file is a factor in determining whether that penalty could be avoided or waived. If you're out of compliance, you received a penalty, there's various procedures you can do. If you've already been penalized, then you have to go down the abatement route. Typically, it includes filing a reasonable cause statement, doing an appeal, collection due process, things like that. If you haven't been penalized yet before you get the penalty, you may qualify for one of the offshore amnesty tax programs. There is voluntary disclosure if you are willful or just can't certify under penalty of perjury that you're non-willful. Otherwise, there's various non-willful programs available to you. There's the streamlined procedures, there's the delinquency procedures, and of course, there's reasonable cause. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.